Hello, everyone, and thank you for joining us today. Dark Patterns, Junk Fees, and Auto Renewals, your summer update, presented by Venable's Auto Renewal Solutions team, or VAST. I'm Shaheen Rothermel. I'm a partner in Venable's Advertising and Marketing Group. I'm joined today by Len Gordon, the chair of Venable's Advertising Group, and previously at the Federal Trade Commission, head of the Northeast Regional Division. I'm also joined by my colleague, Ari Rockman, who is chair of Venable's Autorenewal Solutions team and a partner in our litigation group. We have a lot to cover today, and here's the agenda. I'd like to begin by telling everybody that this is not really going to be a primer in these issues, but rather this will be an update. If you'd like more of the basics and background, we've provided some links here in the agenda. But for the most part today, what we'll talk about is any updates and regulations and laws surrounding dark patterns, junk fees, and auto renewals, as well as some regulatory enforcement and private enforcement surrounding these issues. So we're really going to roll up our sleeves and dive into these and give you hopefully a deep dive and helpful background today. And then if you have any questions, please feel free to put those in the chat. We'll get to those if we can, and if we cannot during the session, we'll get to those afterwards. And with that, I'd like to turn it over to Len to talk about dark patterns.
Thank you, Shaheen, and welcome, everyone. Really appreciate your joining us today. Can I get the next slide, Shaheen? Thanks. So we'll start with dark patterns. It's a subset of deceptive marketing. In many ways, it's just another name for deceptive marketing. The term was coined by Harry Brignall, a user experience specialist. I believe he's in the UK. And he's now made a lot of money being an expert witness in a lot of class actions, claiming that consent mechanisms or disclosures are defective and are essentially a dark pattern. And where you see this playing out a lot is where somebody gets sued and they're claiming, no, the offer was adequately disclosed or consent was given. And plaintiffs, sometimes the government, are hiring people like Mr. Brignall to explain why the consent mechanism or the disclosures were ineffective because they were manipulative. And what is manipulative and a dark pattern as opposed to what is effective marketing is very subjective. It reminds me of Justice Stewart's admonition about pornography. He knows it when he sees it. A dark pattern, apparently the plaintiffs think they know it when they see it, but Brignall's definition is useful. A user interface carefully crafted to trick users into doing things they might not otherwise do. That sounds to me like marketing. But then he gives examples such as buying insurance with their purchase or signing up for recurring bills. The design flaws or design aspects aren't mistakes. They're carefully crafted with a solid understanding of human psychology, and they do not have the user's interests in mind. Again, a lot of that to me sounds like marketing. Deceptive system designs on websites and apps that prey on human cognitive processing frailties. That's how the judge in the Southern District of New York defined a dark pattern. And they went on, dark patterns are deceptive design choices that take advantage of behavioral tendencies to manipulate users to make choices for the designer's benefit and to the user's detriment. And they give some examples. And a lot of this is playing out because the speed of internet commerce especially is increasing. Consumers want as little friction as possible. They want to buy whatever they want to buy, often on their phones. And so when you've got a user preference for speed and you've got limited real estate on a cell phone, there is a tremendous temptation after the fact to Monday morning quarterback or second guess and say, well, this was a dark pattern. And in dealing with regulators on these kinds of issues, one of the things you'll see is that we'll point out that there's what we think is a very adequate and ample disclosure of terms and a very robust consent mechanism. But if the merchant has high chargebacks or high levels of complaints, the government, sometimes plaintiffs, will use dark patterns to say, well, it can't be adequate because you've got these complaints. And the notion that it's the customer's fault, it's not our fault. People don't read. We can't hold somebody's head and make sure they've read every word. That is not cutting any ice at the FTC, the CFPB, or with state attorneys general right now. So why don't we go to the next slide? The FTC has been focusing on this for the last several years. In 2021, they held a workshop to study this. a lot of this is whether choice is obscured, subverted, or impaired. Decision making isn't real, or the consumer is not actually exercising their free will to choose or decline something. They're being manipulated. And again, where manipulation begins and marketing ends is incredibly subjective. The FTC identified several types of dark pattern. A lot of these seem to me like sort of traditional areas of deceptive conduct that the FTC has been going after for years. Misleading ads and disguising ads, advertorials, advertisements designed to look like independent editorial content. I mean, this is an infomercial, right? I mean, this is not something that's new. Comparison shopping sites that claim to be neutral but really rank companies based on compensation. Again, that's typical FTC fodder for the last 30 years. Misleading countdown timers. Again, creating a false sense of urgency. Again, that's a fairly standard marketing device, but is now being challenged as illegal. Now, there's nothing that says a dark pattern is illegal. If the FTC, the CFPB, plaintiffs sue on these theories, they generally have to prove it's deceptive. We're going to talk a little bit about some rules that may shift that paradigm slightly, but that, at least for the most part, they still have to prove it's deceptive. Just calling it a dark pattern isn't enough, at least for now. Other buckets of dark patterns: making it difficult to cancel. The Roach Motel, you check in but you can't get out, and tricking people into buying more than the thing they thought they were buying. Burying key terms and junk fees. Whether a disclosure adequately discloses that you have 10 days to enjoy your free trial and then you have to cancel, or that the subscription will recur. The FTC, the CFPB, plaintiffs are challenging those disclosures after the fact, that either only part of the price was disclosed or other charges aren't disclosed to late in the buying process. Those would be junk fees often, and we'll talk more about those in a bit. The CFPB is very involved in dark patterns. Chairman Chopra is all over this. He started this when he was at the FTC, and it has continued. They've been working, the two agencies have been working together on, especially on digital dark patterns. We're defending cases where they've brought those changes. The CFPB is also very active on junk fees, which is really a type of dark patterns, typically talking about fees that get tacked on later in the process, and that, as the names imply, often are of questionable value, at least according to the regulators, to consumers. So let me flip it back to Shaheen to talk about some of the enforcement that I've sort of discussed broadly.
Yes, thank you, Len. And one of the things I think Len made the great point here is that all of these concepts that we're talking about in the webinar are intertwined. This idea of dark patterns, junk fees, and auto renewals. The regulators and class action plaintiffs really do bring these all oftentimes in one lump enforcement action. The first example of that is FTC versus Doxo. And that case involved an online bill paying platform. So somebody could use Doxo, or can use Doxo, to pay, let's say they have an outstanding healthcare bill. The FTC filed this case, and what it said, first of all, was that Doxo used dark patterns. And what Doxo did, according to the FTC, was that it used misleading or disguised ads. So if you searched, for example, for LabCorp payment online bill pay or other type of similar search terms, you would see websites like this, doxo.com/pay/LabCorp. And people would click on it and go through and use the Doxo service. It was actually a subscription as well, and use that to pay their online bills. And what the FTC said is that Doxo placed these ads to intercept consumers who are attempting to reach their billers directly, and instead sit in between the consumer and the biller so that Doxo could then take a profit through things like junk fees and subscriptions to do that. And what the FTC also said is that at the last stage of the payment process, Doxo just adds junk fees to consumers' bills that in most of the cases consumers could avoid if they had paid their biller directly. And this is really one example here of of what the FTC and plaintiffs call dark patterns is this disguised ads. What's interesting about this case that I found was that we oftentimes will see companies do search term bidding. And under most, we have a lot of times where people say, oh, can I bid on this term? Can I bid on that term? And the FTC and others are saying, well, you can, but if you're bidding on terms and you're presenting things like this that confuse consumers as to your relationship with the entity they're trying to reach, or you're confusing or deceiving consumers about what they're going to have to pay, then that's going to be deceptive. In another case, against a company who has been really hammered by legal issues over the past year or so, the FTC brought a case against Cerebral, and that was an online telehealth platform. In that case, the FTC alleged multiple violations of the FTC Act, the Opioid Addiction Recovery Fraud Prevention Act, and the Restore Online Shoppers Confidence Act, ROSCA, which deals with online subscriptions. One of the things that the FTC alleged with respect to ROSCA and the FTC Act, so what the FTC says is misrepresentation, is the claim that people could cancel anytime, and that customers could contact it via all these different mechanisms, and that there were customer service reps available at all these different times. In reality, according to the complaint, the company required people to navigate really burdensome, cumbersome, multi-step offers. That Cerebral had actually gotten in trouble with the New York AG, where the AG had alleged that what Cerebral did was somebody would email or chat a request to cancel. And even if they chatted or emailed before their cancellation deadline, what would happen is that somebody from Cerebral would email back. And then if the consumer didn't email back until, let's say, 2 days later, and the auto renewal deadline had passed, and so your renewal, then they would get renewed for another term. So according to the FTC, this was problematic, and they said that not only is it problematic as a dark pattern, but also the claim cancel anytime was also misleading. So I see a lot of companies using cancel anytime. It's not always misleading, but you just have to use it judicially. Ari, do you want to talk about FTC versus Float Me? You're on mute, Ari.
Sorry, I didn't realize I was on mute. So this is another case that the FTC recently, I guess, resolved here. It accused Float Me of violating Section 5, standard, FTC Section 5 case with a ROSCA violation for failing to disclose material transaction terms before obtaining consumers' billing information, and the FTC layered on top of that, making it difficult to cancel. And I think this, as we'll go through this summary very briefly, this is a perfect example of the FTC or a regulator or even consumers who are reporting this, starting with this $50 free ad or series of ads at the beginning and leading to the additional problem associated with cancellation. So here the representations were made: get up to $50 cash advance now, or get up to $50 free with no hidden fees, no interest, no credit check. You have 5 different ads here, all talking about $50 in cash advances if you sign up for this membership. But the reality of the situation was if you signed up, you only got $20. And so discovering that alone is a problem, just because the ads say one thing and the consumers are getting something else. But here is sort of where it got interesting. The FTC, as they do, proceeds throughout the flow and the consumer experience and discovered that the cancellation process was manual only, so quote from the case, delay filled and error ridden, and only allowed cancellation via support tickets. For those of you following the changes in California law with Autorenewal, you'll see that that's going to be an issue here. But going back to this case, they responded to cancel requests by asking the customer to describe the problems with the app or telling the customer to cancel another way. The cancellation mechanism wasn't easy. So pretty discrete set of facts, pretty easy for the FTC to come after something like this. I don't know how the amount of the settlement was calculated, but it was $3 million. And I don't know that Float Me was that big of an entity. So I don't know how much I'd read into the $3 million. So now we've got class actions and private enforcement of dark patterns. And this is a new case in the Northern District of California called Dela Cruz versus BetterHelp. And it's pretty detailed in terms of the so-called dark patterns that the plaintiff's lawyers identified. One of them is, and we'll show you how this worked out in a minute, misdirection, quote unquote, misdirection through a web page design that purposely focused the consumer's attention on one thing in order to distract them from another. That's pretty classic misdirection allegation. Brightly colored text offering alternatives to canceling, which were not intended to streamline the cancellation process, but confuse and distract to prevent cancellation. So again, that's another set of audio cues that were, video cues, visual cues to deter the user from canceling. And use of so-called confirmed shaming, where the option to decline is worded in such a way as to shame the user into compliance. We'll see about how successful that is. That typically is not the core allegation in a situation like this, and is normally a tag along. And most, see how they figure that out later in the case, whether, if they do a survey, for example, whether consumers will actually, respond to that, or they don't care how they feel, they just want their money back. And then they have the Roach Motel dark pattern, which is what Len was describing earlier, where you get into a situation very easily, they'll take your money, but then it's hard to get out of the premium subscription. And signing up for BetterHelp was very easy, whereas cancellation was disproportionately burdensome. That's the allegation. Unsure how this is going to play out. Now, here's the go to the next slide. We're seeing this, and Len, I'll cover the first one. I'll pitch the other one next to you. This is actually in the complaint. The visual, I'm not sure why they decided to do this. I'm assuming it's because they're assuming it's going to sway the court in some way, assuming that the judge ever, looks at the complaint. I don't know that a jury would ever see something like this. That remains to be seen. But this is a pretty concise summary of dark patterns. And it's actually has a lot of the terms that we've used in our prior presentations, and it's not completely inaccurate. What I think is misleading about this is to put it into a complaint to suggest that these things are like per se illegal or whatever. I mean, they can be, but for instance, Roach Motel, but it's just, I don't know. It's just, I'm not sure why they did it this way, but if you want a good summary of the various buzz terms, this is it. And whether it's illegal or not is going to depend on the offer and the statute that applies, not the label given to the so-called dark pattern. Len, do you have anything you want to say about this in the next slide?
Sure. I mean, I think this is an effort by the plaintiffs' bar to try and get judges to start thinking about disclosures, disclaimers, consent mechanisms more skeptically, and trying to give some bona fides to the attack on them. That it's not just the plaintiff's lawyer saying this, but there is a body of scholarship. This doesn't really look like scholarship, but it's actually very useful. That is recognizing these things. And we go to the next slide, you'll see more of that. It talks about the cognitive biases that we all apparently suffer from or operate under. And this all fits into notions of emotional intelligence and behavioral economics, and everything isn't rational. For a long time, economics and courts, rational consumers and things like that. And the plaintiffs, the FTC are trying to get judges to think that, well, plaintiffs don't actually operate always rationally, and they have flawed thinking, and it should be what they really want. They want it should be illegal for businesses to capitalize on that. But drawing lines there, I think, is going to be very challenging and becomes incredibly subjective, and I think will lead to inconsistent results, which will make what Ari, Shaheen, and I do really challenging as you're trying to give clients advice on where things where the lines are, and assessing risk for various kinds of disclosure regimes and consent regimes. But the things here are the Dunning-Kruger effect. That one, I mean, I find this in evaluating associates sometimes. Incompetent people overestimate their performance. We're probably all guilty of that one way or another, I'm sure. But the converse, that competent how the common people underestimate is, I mean, it's just interesting. And I think, you know, here you're talking about where people consent thinking they understand something, but they don't. And, you know, the next one, loss aversion, it's fear of missing out. So you present your offer in such a way that you make the consumer think that if they don't hit that button, they're going to miss something. And that could be with, you know, whether it's insurance, if you really not want to insure your trip or things like that. You know, distinction bias, you know, if things are compared, you're more likely to look carefully than if you only get one product or one item displayed to you. Again, you know, is that inherently deceptive? No, but it again, where effective marketing ends and deception begins is somewhat subjective. Information bias and confirmation bias, these are, you know, well recognized phenomena in psychology. And, you know, they, like anything, they can be used to deceive, but they can also be used to provide useful information. Negativity bias, again, you know, is something that user experience designers can use to deceive, but they can also use it just to provide useful information. So none of this is illegal, but I think, you know, plaintiffs are putting this there to try and make their allegations, their challenges seem more legitimate.
Yeah, and I think this will be subject to expert testimony. I mean, as well. I mean, they're going to, it's the same for the previous slide in terms of what the users, how users navigate on a website and what they're tending to see and their cognitive effects. I mean, this will be a big area of expert battles in the larger cases. So here's a good summary of it. I actually think this is quite useful for the way plaintiffs are thinking as of right now. So going back to the case, this is, so we're going to show you a series of screens. This is all happening in one case. Sorry, one website, one screen. And this is why they're saying it's deceptive, is because they're cramming in a bunch of information on that page. And it's not until you get later down in the page, if you go there, where you see the billing disclosures on that same page. And it just states how much it will cost to be billed and renewed every 4 weeks unless it is canceled with the prices. Now, the language is not in larger type than the surrounding font. The color's in gray rather than more conspicuous colors and is buried in the middle of a paragraph regarding the pricing. But I mean, this is still here. I don't know how far the plaintiffs are going to get with their theory, because it's here. I mean, there's a lot here that I think the defendant can work with. Are there some technical violations? I don't know. I mean, I guess the plaintiffs are arguing that. And are there some dark patterns and cognitive things that on the previous slides that the plaintiffs could point out to show that users would not see or understand this? I mean, that's what they're alleging. But I probably would have, you know, that checkout isn't perfect, but I might have used a different fact pattern. If we go on to the next page. So here are the so-called alleged violations. The payment page includes at least 3 computer screens of text. That's what we really get previously. The payment page has a long list of features. Again, that was so that list. We had all the check boxes. The cost is displayed in bold, but only to favorably compare to the cost of going into the office, seeing in a traditional in-office therapy. And any supported disclosures were overshadowed by the page's other components. This is misinformation. I would also call it misdirection dark pattern. And we got into the font size there on the payment screen. So that's what they're alleging. We'll have to see how far they get with that. They're in a pretty favorable jurisdiction for plaintiffs. And so we'll only time will tell on that one.
And just while on that, I mean, Ari was mentioning expert testimony, and you're going to see, you know, not just consumer surveys on these things as to what consumer, you know, I think you'll see that, but you'll see consumer experience testing using heat maps and things like that, looking where people's eyes are, and, you know, plaintiffs or the government trying to prove that the website is designed in such a way that people's attention is specifically directed away from certain terms and towards other terms through colors, font size, things like that. And, you know, some of these plaintiffs are going to try and prove that through, you know, heat map testing and other testing. We'll see if that works, but. It's much easier to allege than to prove, as we all know. So junk fees, hot topic these days. Junk fees is, an attack on junk fees is part of President Biden's agenda. I mean, he's talked about this at the White House and the Competition Council. And, as you'll see as we go through what's going on, it really is sort of a whole of government, not just the FTC, but the CFPB and then some of the other industry-specific regulators are all piling on this bandwagon. The name obviously is pejorative. It is, that people are being charged fees for junk, for things that they either didn't want or didn't need or didn't order. And as we'll go through what the FTC is doing there, you'll get a sense of the issue. So why don't we go forward? Junk fees and drip pricing. I mean, the FTC's been looking at drip pricing for a while. Both the Bureau of Economics has held symposia on that, and the FTC's been looking at it. And the notion is that consumers aren't told the price all up front, that it's dripped out as they proceed through the sales process. It gets a little bit here, a little bit there, and they allegedly are trying to use momentum, inertia in the sales process to get people sort of committed to buying something before they understand the price. Junk fees is more, fees for things that are unnecessary or unavoidable, or surprise that materially inflate the price while adding little to no value. And drip pricing is, again, sort of you get the price drip by drip as opposed to all up front. So what is the FTC doing? Well, in November of 2023, they released a proposed rule targeting what it called unfair and deceptive fees. They held a hearing on that on April 24th, 2024. The hearing was not a robust exchange of ideas. It was not as contested as some people thought it should be. We'll see. What else the FTC does. We'll expect the final rule will come out relatively soon. The Biden administration is trying to push out as many rules as possible, as soon as possible, to avoid having those rules challenged by the Congressional Review Act. The rule, if enacted, would apply. Go back one, Shane. I'm sorry. To companies that are providing, but also to resellers. So affiliate marketers or online travel agents. All are covered there. And there are two big no-nos. One, omitting mandatory, that word's important, charges and fees from the advertised price. And two, misrepresenting the nature and purpose of the charges or fees. And we'll get into a little bit more, but it's really two different things. One, omitting mandatory fees, and two, misrepresenting any fees as to the nature and purpose of those. All right, thanks, Shane. Can we go to the next one? All right, so hidden fees. You're prohibited from offering, displaying, or advertising an amount a consumer may pay without clearly and conspicuously disclosing the total price. If an offer, display, or advertisement contains an amount a consumer may pay, a business must display the total price more prominently than any other price information. So you can't say it's $10 and then have the fees below it. You can have $10 being the big number and then the fees below it without disclosing what the total price is. That's got to be on the page, the most conspicuous price. The misleading fees, nature and purpose. You can't mislead what they are. You can't mislead whether they're refundable. You can't say it's for a gratuity that's going to be paid to a driver, for example, if that money is not really going to go to the driver. Got to conspicuously disclose the nature and purpose of any amount the consumer must pay that is excluded from the total price, including the refundability of fees and the identity of the goods or services for which fees are charged. So handling charges, processing fees, things like that, especially when they're mandatory. If you're saying processing fee is $15, you need to be able to explain why it costs you $15 to process whatever it is that you're processing. It can't be a way just sort of to hide margin. Again, total price clearly and conspicuously must be disclosed. That means in FTC parlance, difficult to miss, unavoidable, and easily noticeable. It's got to be the most prominent price. The total price is the maximum total of all fees or charges the consumer must pay. Again, mandatory, must, for a good or service, and any mandatory ancillary good or service. You can't, tell people what the price for a car is, but it doesn't include tires or wheels. I mean, and the only carve outs are shipping charges and government charges. Now, before we got started, the three of us were chatting and like, how do you deal with this where you've got a complex product, right? So, there are options that someone always pick. I mean, I think you probably are going to have to use language like starting at, and, then as the consumer works their way through the process, they have options. They can choose the more expensive option. They can choose the less expensive option. That because those fees for the initial disclosure aren't mandatory. That price isn't mandatory. You don't know what it is yet because the consumer hasn't made those choices. Now, I will say, if you have images and descriptions of the luxury model of something, and your ads are saying, costs what the base model costs, whether you view that as the junk fee rule or just basic deception, you may run into some problems. So, if you're going to be showing a price where you've got options available, the price you're showing and the model or the service that you're touting probably should be relatively close or have very, very clear disclosures about that. Next slide. Okay, so what are mandatory ancillary goods or services? They're goods or services offered to a consumer as part of the same transaction that you cannot avoid paying at the completion of the transaction. Optional, doesn't even close. They're optional. The consumer can decide whether or not it wants those. Shipping charges, it's got to reasonably reflect the amount the business incurs to send physical goods to a consumer through the mail, including private services. You can't inflate those to try and inflate your margins. That's going to be a problem. Shipping charges, we just talked about that. Government charges, so fees imposed on consumers that the merchant is required to collect, taxes, for example, those don't have to be disclosed until the end. But if a business has costs for licenses it gets from the government, or rent it pays to the government, or fees it pays to the government to provide this good or service, and it can't allocate a portion of that to each transaction and then tack that on at the end, because that's not something that's paid by the consumer. That's something it's overhead cost that the business is allocating to the consumer. That's got to be included in the upfront price. And it's the maximum price. If at checkout you offer somebody a discount or through a code or a special offer, that's okay. Much more concerned about making sure consumers understand maximum price as opposed to discounts they might get down the road. Nature and purpose of charges, charging multiple fees for the same thing, or under the same label if they serve just distinctly different purposes. Again, we're trying to avoid consumer confusion. The FTC got comments on the rule about things like convenience fees, improvement fees, economic impact fees. Consumers don't know what these are, and if you're going to charge those, they've got to be included in the upfront price. You can't shove them in at the end. They used an example of a meal delivery app that could not charge both a fee to compensate its drivers and a fee to run the service under the same label or line item. It must be two separate fees, and again, it's going to have to be included in the total price. You've got to disclose how those fees are being allocated. If you're saying it's a gratuity, you've got to explain how much of that gratuity the driver actually gets, as opposed to what you keep, and also if it's refundable.
And that's a great example. And there was a case against Grubhub that we spoke about in our in one of our recent webinars that are linked in the beginning. So if you want to see about that'll give you some good examples here that put this into play in an enforcement action. In addition to the FTC's rule, there are a number of industry-specific rules concerning so-called junk fees. The first is one that would regulate airlines and travel agents and require them to disclose any upfront charges for things like baggage and canceling or changing a reservation. Now, that is currently being litigated. We've got a couple major airlines who are challenging the administration on that. But if it goes into effect, it would require airlines to provide really accurate and transparent information about things like baggage fees, change fees, cancellation fees. It would require specific disclosures, things like the fact that a seat is guaranteed, even if a seat isn't assigned. Somebody doesn't need to pay to get a seat on an airplane. They'll have a seat guaranteed. But as I said, major airlines are currently litigating that rule, so we'll see what happens. Similarly, the FTC's CARS rule would add truth and transparency to the car buying and leasing process. And it would make certain disclosures required, such as disclosing in writing that the purchase of optional add-ons isn't required for a vehicle purchase or lease. However, that is currently being litigated as well, and FTC issued an order saying that it was going to pause enforcement on that. The Federal Communications Commission, FCC, does not want to be left out here either. So it has proposed a rule that would prohibit cable operators and direct broadcast satellite service providers from imposing early termination fees and billing cycle fees. Something that the FCC would prohibit in that rule would fees that subscribers have to pay if they terminate the video service contract before its expiration date. The other thing the FCC has proposed prohibiting is something a lot of companies do across the spectrum, which is if somebody cancels before the end of a billing cycle, even if the customer doesn't want to use the rest of the billing cycle, they still have to pay for the whole billing cycle because they've paid for access to it. A lot of companies do that. That's pretty industry standard. The FCC's rule would say, no, you can't do that. You can't require people to pay for something that they're not going to use. The CFPB also proposed a rule to stop certain junk fees on bank accounts, including fees on transactions that are declined at the time of swipe, tap, or click. So it would prohibit NSFs or non-sufficient fund fees on these transactions that decline in real time. So let's talk about a couple of the regulatory actions. I previewed this on the Doxo case earlier. Remember, if you'll recall, that was the one where it was a service that allowed people to pay their bills online. Another one of the allegations in the case that the FTC brought was this idea of a surprise delivery fee that was mentioned in gray font on the checkout page without explanation. So you can see here it says includes $3.99 payment delivery fee with a little question mark that I presume would explain that. What the FTC said is that people don't understand what they're paying. And the FTC also said that in some instances, this delivery fee exceeded the amount of the bill. So in those instances, a customer could have just gone to their biller and paid the bill rather than pay Doxo, and then they ended up paying like twice the amount because they're paying Doxo a delivery fee, according to the FTC. The other thing that the FTC said is that Doxo then would do a charge on credit and debit card payments, and that the billers themselves did not actually charge for bill payments made to them directly. So customers were paying millions of dollars in these delivery fees that they wouldn't have been charged anyways. And I would be remiss as a member of VAST if I left out this subscription part here, which was that Doxo also allowed people to enroll in a subscription program where they would pay a monthly fee. And for that fee, they were told here that they would not have to pay the subsequent delivery fee. So you see here, it says save $3.99 on this payment if you agree to pay $5.99 per month. What the FTC said is that even if people would sign up for this and say, okay, fine, I'll pay the $5.99 a month, Doxo would still charge those subscribers the delivery fees. In other words, people were paying for a subscription, but not getting the promised benefit. Again, according to the FTC. We'll see how that plays out. In one of the only private actions where a company is finally fighting back is a case that was brought against SiriusXM. And I have to say Sirius is sort of fighting the good fight for a lot of companies on this issue. In this case, the plaintiff was a subscriber to Sirius, or two plaintiffs actually, who signed up by telephone. They had for SiriusXM streaming service. And what they allege is that Sirius failed to inform people who signed up by telephone of a specific fee that they would have to pay, this U.S. royalty fee that was paid on top of the monthly fee, and it was 21.4%. And Sirius's response was, no, wait, we've disclosed the fee, including throughout the purchasing process and in all of our materials. And I know this isn't big enough here for everybody to see, but once you get the slides, you'll see that in the offer details here on the right-hand side, there's bolded language that specifically tells people to please see our customer agreement. And it also alerts people to the fact that additional fees and taxes will apply. So really, I mean, people are put on notice. And anybody who's familiar with the FTC's case against DirecTV back in 2015 under Rosca will know that this is actually not so different than the case, than the ads that a court reviewed there and found to be okay as a matter of law and granted summary judgment against the FTC. So, you know, we'll see what happens here. The problem at this point is that we're at an early stage. So Sirius had argued that, look, we've disclosed that there are additional fees. People will see the fees as they get along. The purchasing price, and we give people a receipt that explains all the fees to them. And the court essentially said, we're at a motion to dismiss, and under the motion to dismiss standard, we take everything in light most favorable to the plaintiff. We assume the reasonable person standard, so we're going to give everybody the benefit that they didn't see, they didn't know. And so the court has rejected the motion to dismiss, but that's not to say that it's not going to, that Sirius won't succeed at a later stage here. I think one of the interesting parts of this too was that Sirius pointed to a lot of cases where New York courts found in favor of the company where the company provided notice of the charges before purchase. In other words, you had a fee that's, hey, $5 a month on the front end, but then the fees were disclosed later, and court said, yeah, that's fine. People understand, they were told. So we'll see what happens here. I think maybe there's an issue because it was telephonic. I'm not really sure, but I think this is a case that we'll be watching to see where this comes out, particularly the interplay between this case and all of the other laws and rules that are coming out. I will pause and give everybody the CLE code. The CLE code is Dark Patterns 2024. Dark Patterns 2024.
And that's a good segue into what we're going to see in terms of uncertainty and litigation playing out for the junk fee rule. So this law in California, it's part of the CLRA, goes into effect on July 1st of this year. And it revises, or maybe even supplements the CLRA to prohibit junk fees and drip pricing by making it illegal to display or offer a price or a good or service that doesn't include all the mandatory fees or charges other than taxes or fees imposed by a government on the transaction. So for example, if the web funnel, you're just selling one good or service is for $29.99, you don't have to disclose taxes or fees would be like fees imposed by government on the transaction. So it's not processing fees or handling fees necessarily. We'll get to that point in a minute, but you can't include, add-on charges, 2, 3, 4, 5, or 6 add-on charges later. It has to be disclosed here. At least that's how the statute reads. And the penalties are at $1,000 per violation plus an injunction, and there's a private right of action for that. You can bring a private right of action, but we go to the next slide. There's sort of some twists and turns associated with that. So here's some FAQs from the California AG. Handling and related charges are not excluded from the advertised price. So you cannot exclude handling charges from the advertised price, but you still can exclude shipping charges if they will be reasonably and actually incurred to ship the physical good to the consumer. So some reasonable relationship between the shipping charge and the cost of postage, for example, can be excluded. But if you're going to tack on some sort of handling charge that's largely not being passed or not from a third party source like the Postal Service, then this would not apply. And just so this is different than the auto-renewal change laws that happen later that talk about promise. This is just the CLRA on drip pricing and junk fees. Then on the uncertain pricing and variable charges and fees. And this is, we're going to have to see how this plays out. If your business model, like the ultimate price depends on what the user selects, and that changes from the time you're on the landing page until you get to checkout, this law doesn't clearly delineate what happens in that circumstance. And that will be something that needs to be probably litigated, because there's a lot of, California is very active on the class action bar on things like this. Our best educated guess is that if you have a situation where you're adding things to your cart, or you're customizing the service, you're customizing the good, and the price is changing as you do that because you're adding things, that part's probably okay. What's not okay is you start off at, in my hypothetical, $29.99. You add things, customize the plan, maybe buy 2 things. Turns out to be $150 because you've added some additional items, or as to items that you selected, you added some enhancements to it. And then you go to the checkout page, and all of a sudden it's $150 plus the shipping and handling. Let's say it's $10 for the U.S. Postal Service, but then there's this other $30 fee, customization fee or something like that. I'm just making that up, where they sneak in that $30 at the end. That part is probably where the problem is going to arise with respect to uncertain pricing and variable charges, because it's impossible to predict how any given user, my argument is impossible to predict how any given user, when you have a good or service that is being customized, is going to, like, what they're going to pay, what they're going to do with it at the end. Restaurants, gratuity, and food delivery. Restaurants do not have to incorporate the delivery fees to the price of menu items, but they still should disclose the full all-in price of delivery. There's an overall mandatory fee that must be included in the advertised price. So that's the change there. Let's go to the next one.
Hey, Ari, can I just mention one other thing?
Yep.
California also has a separate law regarding the hotel industry. It's only enforced by the AG, but the civil penalty there is $10,000 per violation, and that also goes into effect on July 1, 2024.
And then there's other states that are looking into this. Massachusetts, Pennsylvania. Massachusetts would prohibit misrepresenting or failing to disclose clearly and conspicuously at the time of the initial presentation of the price, or any subsequent presentation thereafter, the total price of the product. So that's another way of saying you've got to put everything in the price when you show it to them the first time and every time thereafter. Pennsylvania has Pay the Price You See Act. It's pretty self-explanatory, but it's the same idea. We've included the text there. And then there's some surcharging laws as well that are coming down.
And finally, we'll talk briefly about some automatic renewal law updates. The biggest one that's coming down the pike is California's updates to its automatic renewal law. It's already the most onerous in the country, and the legislature is being very quiet about this bill, 2863. Last week, it just moved forward. It passed the Assembly, and now it's moved on to the Senate. So moving forward, what it would require is affirmative consent. It would require companies to obtain the affirmative consent to the automatic renewal service separately from any other portion of the contract. This is what the FTC and California regulators have been asking for years. They've been putting that in all their settlements. The way they have interpreted it is that you need to have a checkbox or signature line, radio button, something similar that requires somebody to agree to the auto renewal term separately from everything else, including separate from the call to action needed to complete the purchase. I think one of the reasons we're seeing these amendments is because courts are pretty uniformly agreeing that the current California law does not require an affirmative checkbox. And so I think the legislature is trying to address that here. The FTC, obviously, they've got their negative option rule changes that would require the same thing. And this is actually pretty similar to that. So it would also prohibit companies from including any information that interferes with or detracts from the auto renewal disclosures. It would prohibit a company from misrepresenting any material fact related to the transaction. including any material fact related to the underlying good or service. So again, we're seeing California move closer and closer to what the FTC is requiring to wanting to do in its rule. It would require companies to let customers cancel their subscription in the same medium in which they use to enter the auto renewal. One thing that we're getting asked is whether or not that means on apps. If somebody purchases through the app, do they have to cancel through the app? What about a mobile web? So that's something that we're going to see. It would require annual reminders with specific mandated disclosures, even if the term is not 1 year or longer. In other words, if you have a monthly subscription, once you hit that 12-month mark, then you got to give the disclosure. That's we see that in Colorado, but Colorado is much smaller than California. So this would be the rule then in California as well. If this does pass, it would apply to contracts entered into, amended, or extended on or after January 1st of next year. So we're keeping an eye on that, and we'll keep everybody updated. If you're on our ad law list or our VAST subscriber list, you'll get updates there via email. Here are some additional new state laws and amendments. Virginia updated its auto renewal to apply to business contracts. I don't mean to usurp what Ari's about to talk about, but he's going to talk about the Shutterstock case, where the court actually, in a previous version of that case, it had found that the plaintiff couldn't state a claim because she wasn't a consumer. She didn't allege that she was a consumer. Most of the auto renewal laws that we see now apply for consumer transactions, someone who gets something for their personal, household, family use. Virginia has now expanded it. Auto renewal laws apply to business contracts explicitly. There are new cancellation requirements in Connecticut, Georgia, Illinois, Vermont, Virginia, Tennessee, New Jersey. This is in addition to all the new laws we've seen in California, in New York. The AG has brought a number of settlements there. People are geogating. We see the geogate on the California cancellation side. They say, okay, well, we'll let people cancel using that online prominent link in California, and only for California customers. That's going to get more and more difficult as these laws are coming out basically every month, if not every 2 weeks. And then Utah has now imposed additional requirements for auto renewals, including including trials and auto renewals of over a specific period of time. Or you want to talk a little bit about the class action trends?
Yeah, so there's a lot of just coming in through the chats. We can't feasibly get through that, but if there's any questions remain after we get through this, please reach out to us. This is what we do. We're happy to engage with you about that or discuss it with you. So the trends in class action litigation, that is increasing, an uptick in these kinds of cases, hand in hand with the auto renewal cases, alleged violations of that's a federal statute we've been talking about, the Electronic Funds Transfer Act. Biggest areas, challenges to material changes. Well, it's also failure to disclose billing terms, but challenges to material changes, we're seeing that come into play more. Streaming services that advertise as ad-free that subsequently introduced advertisements to the lower tier service where required customers to pay more for ad-free viewing. That's a material change that was identified. Challenges to cancellation mechanisms and processes. Challenges to early termination and cancellation penalties, also referred to as early termination fees, and challenges to order acknowledgments. This is sort of a checklist, which is sort of like the checklist we have in the California state court system as well for the automatic renewal law there. But this one's a little not as long or detailed, but the same general principles would apply. The next slide. This is what Shaheen was referring to in the Davis versus Shutterstock case. This is where you have this is what the screen that was challenged, and you can see underneath the subtotal, the $29 was taken off. Shutterstock will automatically charge the monthly subscription fee, $29, to your payment method every month for 12 months until your subscription has expired, unless you cancel before the end of your free trial. There's bolding involved. Unless you cancel before the end of your free trial is very important language, probably the most important language, arguably, other than possibly the $29 auto renewal. So that's a point that I think is here. We go to the next slide. So here's what they complained about. Did not use bold, highlighted, all capitalized, or different colored text for the automatic renewal terms. and there's no call out box or anything like that near the terms. They appear in small font, that's the allegation, and are deliberately difficult to read. Now, here are some things that they didn't disclose here, which the private class action lawyers are complaining about. There was no description of the cancellation policy. There was no description about how the consumer would be charged, whether it was to the credit card or debit card. Sometimes we use PayPal, whatever it was, or when the consumer would be charged. It just says, I think, unless you cancel before the end of your free trial, that doesn't say when you're going to be charged. And when the plaintiff attempted to cancel her description on March 29th, and this is sort of like probably what really is this maybe the strongest point from the plaintiff's arguably, she was charged $40 as an early cancellation fee. And I think that particular decision to impose that fee, even though legally it's, all the violations are technically the same, that was probably one that made this case a more persuasive one than the plaintiffs said. I don't know if you agree with that, Shane. But that's what I think about that one. And then we have Octavia, another example. Plaintiffs allege that the customers could enroll in the premium monthly subscription through interactions with coaches. The coaches were allegedly trained to take the consumer's payment information and place an order for the consumer using the website. And the allegation there was that the defendants allegedly told the coaches who are taking the orders to suggest to consumers that they are placing a single one-time order. And they challenged the pre-check checkbox on the website. That's an obvious violation there. That case is out there as well for Octavia. The court denied the motion to dismiss there. And so I guess we're going to have to see how that plays out. We're running out of time too. So I think we should move on probably to CART, the California Automatic Renewal Task Force.
So the task force is busy. I think they're going to get busier. Just mention three cases quickly. They went after Thrive, a meal delivery service. Settlement was real money. $1.55 million in monetary relief. 450 of that was in credits. So that's a little easier for a business to absorb. But then $1 million civil penalty. That's going to hurt. The New York Times, the paper of record, something that people know they subscribe to. I think everybody knows when you subscribe to a newspaper at Autorenewals, but they were still sued because their post-purchase confirmation email didn't satisfy California's requirements. So I think that's a good example of how strictly these requirements are being applied by the task force. And then Boaks, a floral delivery service, had to pay $240,000 and update its practices to comply with California's auto-renewal law. So you're going to see more here, but this is, I think, the tip of the iceberg. Camel's nose, whatever you want to use.
Yeah. And we've gotten so many great questions through the Q&A, and we'll follow up with those after this presentation. But if you have any questions, please feel free to reach out to us. We realize that these laws are passing ridiculously quickly, including in the summer. So compliance, if you want to get into compliance, you have questions. We see there are a lot of really great questions. We're happy to answer those. Please feel free to reach out to us or anybody else on our team.
Thank you all.
Thank you, everyone.
Happy Memorial Day.